Here's a headline from a viral news story. Mother fights HOA after receiving letter complaining about son playing on a magnolia tree. How does a child waiting for the school bus become the center of a national controversy? And why was this contentious outcome more predictable than it first appears? Welcome to HOA Case Files. This is our very first case, Florida HOA versus a 5-year-old. This case comes from Orlando, Florida. The homeowner, Ariel Berner, received a letter from an attorney representing the University Pines Property Owners Association. According to the letter, children have been climbing and swinging from the branches of an association-owned tree, and in so doing, damaged the tree. The attorney's letter also alleged that children had thrown rocks throughout the neighborhood. The association cited a provision of its governing documents prohibiting activities that are, quote-unquote, noxious or offensive, or that, quote-unquote, may become an annoyance or public nuisance. It then went on to state that a failure to follow the governing documents of the association will result in pursuing compliance through mediation. And the letter explained that the homeowner would bear the cost of the mediation process. Just how much could that cost? Well, we can get a clue from the attorney's fees for drafting just this one letter. As part of the process, the attorney instructed the owner that she was responsible for paying $382.16 for the attorney's fees for the letter itself. After demanding the money, the letter states, while the association does not desire to initiate legal or other punitive action, and it's first attempting to resolve the situation amicably with you, rest assured that it will vigorously enforce the provisions of its governing documents through litigation. Ariel Barner, the homeowner, stated she had received no prior warning, that there was no proof her son had damaged the tree or thrown rocks, and that the association's governing documents did not require parents to supervise children at the bus stop. Those are the reported facts. Now let's turn to the investigation. Whether the tree was damaged or rocks were thrown fade in importance the moment the association sent the letter. An ordinary neighborhood concern became a legal process. What could have been an informal conversation became a formal enforcement. A seemingly minor disagreement became a question of authority, respect, and trust. That shift explains almost everything that followed. Why? Why did this happen? What organizational patterns explain why a kid playing at the bus stop could become a national news story? Before deciding whether anyone handled this situation correctly, let's look at how every homeowners association is designed to function. Homeowners elect a board of directors, the board establishes policies and oversees the association. Many boards hire a management company to carry out the day-to-day operations. And when necessary, attorneys provide legal assistance and assist with enforcement. Just as importantly, information should flow back to the homeowners through financial reports, meeting minutes, and regular communication. When authority, communication, and accountability remain in balance, the system can work remarkably well. So here's the question. Where did the governance system begin to break down for this HOA? Let's examine the health of the organization itself. Communication appears weak. The homeowner received no warning before the attorney's letter, while the association later stated that there had been informal efforts. Regardless of which account is correct, the communication itself became part of the dispute. Transparency, however, appears relatively strong. The attorney's letter identified the alleged violations, cited the governing documents, and explained the next procedural step. Procedural fairness, however, needs improvement. We'll dive into this in just a minute. Oversight and accountability appear strong. The association had governing documents, an enforcement process, and legal counsel. Obviously, conflict management is pretty weak. Instead of resolving the disagreement, the conflict escalated dramatically. And finally, trust is very low. Let's look at what changed through our first lens, the concept of procedural justice. People don't judge organizations only by the decisions they make. They judge them by the fairness of the process used to reach those decisions. Imagine receiving your first communication, not from a neighbor, not from a board member, but from an attorney. How would that change your perception of the organization? From Barner's perspective, several things mattered. She said she received no warning. She questioned the evidence, and the governing document language appeared broad. And the first formal communication said she owed over $300. Once the process itself is perceived as unfair, the conflict often stops being about the original issue. In this case, whether the child damaged the tree and threw rocks. Instead, the conflict becomes about authority, respect, and trust. This case also illustrates another important organizational pattern, that of role conflict. HOA board members occupy one of the most challenging roles in any volunteer organization. They're neighbors, volunteers, elected representatives, financial stewards, and sometimes they become rule enforcers. Those roles don't always point in the same direction. When the board enforces the governing documents through a formal process, the attorney lever, they are no longer viewed primarily as a neighbor. Instead, their role as enforcer takes center stage. Finally, there's one more organizational dynamic worth considering in this situation, the role of the legal counsel. Attorneys serve an important purpose. Their role is to reduce legal risk and ensure that organizations follow their governing documents. But reducing legal risk isn't the same thing as reducing conflict. Legal processes are designed to create clear records that document every interaction and event. However, neighborhood relationships are built through informal, undocumented conversation. Once an organization becomes a legal process, escalation often becomes more likely, and the opportunity for personal discretion to change the nature of the interaction is missed. Look back at our governance model. Notice something? Rules don't enforce themselves. People interpret them. Boards exercise judgment, managers implement decisions, attorneys provide legal guidance. At every step, human judgment matters. Discretion matters. That's why similar conflicts appear in communities across the country, not because the rules are identical, but because organizations repeatedly face the same challenge. How do you exercise legitimate authority while preserving trust? Every neighborhood has stories. Some make the news, most don't, but each one reveals something about how organizations work and how communities can work better. Take a moment and ask yourself, how would your association have handled this? If you enjoyed looking beyond the headlines and uncovering the organizational patterns behind real HOA cases, I'd love to have you join us. Subscribe to HOA Case Files, and I'll see you when we open the next case. Facts tell us what happened. The organizational patterns explain why.